thank you very much for visiting our office and hearing our lecture about the requirements, the main requirements in order to obtain patent protection. There are further requirements, but I'm presenting only the main requirements which are of interest for you. The further requirements are not of interest for you. For example, problems with regard to... Yes?
Is it possible for us to get the material later on?
Yes, of course.
Okay, thanks.
Okay, let us start with the first page. Okay. First of all, I think it is helpful to understand the intention of a patent. The inventor will get protection for up to 20 years, and the inventor have to inform, for this reason, the public about his invention. This is a deal between the public and the inventor. In this way, it is possible that there are inventors prepared to disclose inventions. Otherwise, an inventor would not like to disclose an invention because he had the workload, and if every further party is allowed to copy his invention, another party, a third party, would have an advantage because the further party must not develop something. And for this reason, a patent application as well as a patent has two different parts. One part is the description and the figures. And the object of the description and the figures are to disclose the invention. For this reason, an inventor has to disclose the invention in such a way that a third party is able to carry out the invention. If a third party is not able to carry out the invention due to the description and the figures, the inventor didn't disclose a new technique to the public, and for this reason the public will not give the inventor a protection for his invention. And the second part of a patent application as well as a patent are the claims. As a rule, only a few claims, in many cases often the first case, is responsible for the protection. The claims define the protection for the invention, and the difference between a patent application and a patent is that a patent application is only the beginning. The patent application must comprise the disclosure of the invention, and there are claims, and the claims are something like a proposal for the protection, what might be possible. And then corresponding office, for example the European Patent Office, will carry out an examination, and at the end of such an examination the European Patent Office may grant a patent, and during such an examination proceedings it is possible to amend the claims on the basis of the disclosure in order to come to a protection which is allowable compared with the rules and the requirements and so on. And for this reason, yes, what is of importance that there is a technical problem and a technical solution for this problem. This means a design, you cannot obtain patent protection for a design, for example. You need a technical solution and a technical problem. If there is a new design, there are further rights. For example, a design model. In this way, by filing or by filing an application for a design model, it is possible to obtain protection for a design. If your products have a new design, you can obtain an additional protection, but as a rule, this is my understanding, your company develops new products in the technical respect, and for this reason the patent is the correct right for you, for your interests, in order to protect your developments. Okay, now let us have a look for some technical objects. Do you know what this is?
A vacuum cleaning robot.
Yes, a vacuum cleaning robot. Here is a further vacuum cleaning robot, and here is a conventional vacuum cleaning
Robot.
No robot.
First I thought the roommate she forgot to take it.
Okay, and I want to demonstrate the requirements due to these different robots. And let us assume this is a new one, this is your new development, this is an old one, and this is an old one. It is not true, but I think this is the newer one, but this type of robot, or vacuum cleaning robot, represents a typical design of elder vacuum cleaners, and for this reason I took this one. And I think I think it is very easy to discuss the requirements due to these three types of vacuum cleaners. Okay, let us start. All of these devices clearly meets the first requirement, that there is a technical problem and a technical solution. And of course, one technical problem is to clean a room. And these three machines are able to clean a room, and for this reason, it is all three types of machines fulfill the first requirements in order to get patent protection, that there is a technical problem and a technical solution. Okay, and now please, we go to the next page. As the first requirement, the most important requirement is novelty. And because an inventive step, there you can discuss a lot of things, why there is an inventive step, and you have a lot of possibilities. But novelty is the main requirement. If there is a new development in your company, and this new development has a value, an economical value, and you believe that the new development is new over the state of the art, then you should think about a patent application. Because due to the economical value of your development, this is the most important thing. You do not want only to have a patent. A patent is nothing. You have to pay to the lawyer, this is all. Yes, the only reason to go to a patent lawyer is that you think that you are able to earn a lot of money, or money, due to the new development, and at that stage you should go to the patent lawyer and say, here is something new, and it has a high value for our company. For this reason, please have a look or check whether patent protection is possible or not.
Just as in, what are the costs for a patent?
This depends on the situation, or where do you want to file a patent application. For example, you may say, in order to prepare and file a German patent application, about 3,000 euro you have to pay this sum.
And then there is a yearly...
Yes, there are further fees, maintenance fees, for example, and if there is an examination proceedings, you have to pay for the examination proceedings. But in order to start, you have to pay at least 3,000 euros, and afterwards you may decide the further steps independence of your economical success. And if there is an economical success, then the amounts are not very high, but of course if you have to pay for a lot of patents and there is no economical success, then you will run into problems due to patents and patent applications. Okay, novelty, what does this mean? Invention is not new if an identical technical solution has been made available to the public prior to the filing date. This is not true at the moment for the US, but at the moment the US government tries to amend the law, the Patent Act in the USA, so that this is also true for the US. But in all other countries of the world, the filing date is the most important date. The examiner who examines patent application will look for other solutions, other similar solutions prior to the filing date. And what has been disclosed after the filing date is not relevant for checking whether the invention is new or not. New means a device or a machine or something like that, or proceedings for example, is new if there is no identical corresponding device. And for this reason we can say if this is the newest one and you came to me for example and asked me for patent protection for this one, and you say okay, I know this one and this one, we can say this one is new. What is new compared with this one, for example?
Well, the form. In this case,
Yes.
I would only say it's the design.
The design. This the shape. This has another shape compared to this one. This looks like a circle. And here you can also say this shape is different. Yes?
Like,
Okay. Now, to form such a shape, there is a technical proceedings for this reason. This may be a technical solution, but for this reason we can say, okay, this one is new over the two further devices due to the shape. And otherwise, if there would be a similar vacuum cleaner having the same shape, we can say, okay, this is not new. It is possible that a patent application discloses two different shapes. For example, discloses a vacuum cleaner may have a shape like a circle, like this one, or a vacuum cleaner may have a rectangular shape. Yes, and then there is a teaching. The shape may be rectangular or square or something like that, and like a circle. And the combination of these two shapes would lead to this shape. But despite the fact that the two shapes are disclosed in one patent application, these are two different devices. And these two different devices cannot destroy the novelty because a patent application does not disclose the combination of the two shapes. Yes, it is.
Unless it's stated in the application itself.
Yes, of course. The disclosure of an application, you have to look for the disclosure.
Yeah.
And if there is a disclosure, directly and unambiguously, that a vacuum cleaner can have this shape, this would destroy the novelty. But only to disclose similar shapes and a lot of similar shapes, and you can make a combination which would lead to this shape, cannot destroy the novelty.
but as far as I understood, the first thing needs to be that the shape has a technical purpose, isn't it? Because otherwise we would talk about design, no?
Yes, yes, of course. Otherwise, we would talk
So
about
there
design.
needs to be a disclosure that this shape, for this reason, comes better to corners, or it works
Yes.
better in corners, and that's why the shape is like that, or isn't it?
Fine.
The
It is-
design in itself wouldn't be
True.
better than protect.
Yes. But at the beginning we said this device has clearly a technical effect,
Mhm.
clearly solves a technical solution, a technical problem,
Okay.
and presents a corresponding solution.
Okay.
And one technical object is to clean a room, and this device is able to clean a room. For this reason, the first requirement is fulfilled. Yes, that there is a technical object and a technical solution. You will obtain pattern and the difference between due to the shape can have the result that this device is new over this device or over this device. And you directed the attention to a correct point, but your point is relevant for the further requirement, and now we can go to the next page, and this is inventive step. This is inventive step according to the so-called European problem solution approach. A similar approach is true for many different countries in the world, and but I think it is easy to understand the problem solution approach, and since the European Patent Office is very important for many companies, I decided to present the European European problem solution approach. And then we will come to your point. First of all, this is a new one. These are, let us assume these two types are elder ones. And first we have to determine, there are 3 steps. The first step is determining the closest state of the art. The second step is establishing the objective technical problem to be solved. And now I can give you an answer at once. If we say, okay, this one or this one is the closest prior art, and the difference is the shape, and if it is not possible to establish a technical problem due to this different shape, then the result is that there is no inventive step. Yes, and the third.
So this would be the closest prior art, because
We will discuss this
Okay.
within a few minutes. And the third step is considering whether or not the claimed invention, starting from the closest prior art and the objective technical problem, would have been obvious to the skilled person. This is only a sentence at the moment, but I will explain these 3 steps in further detail. Okay, please let us go to the next page. Closest prior art. We have to look for a single piece of prior art which corresponds to a similar use and requires the minimum of structural and functional modifications to arrive at the invention. Okay, let us assume now today is the filing date of this patent, of this vacuum cleaner, and the examiner looked for state of the art, and he realized that this vacuum cleaner has been disclosed prior to our filing date as well as this one. Okay? And now we have to look for a single piece. Single piece means we have to decide whether this one or this one is the closest prior art. It is not allowed to make a combination of the 2 ones and to say, okay, a combination of 2 cleaning robots or vacuum cleaners is the closest prior art.
But so to interrupt, one question, but this means that it's also important how do I define my problem. Because if I define the problem as
Yes.
cleaning a room, the closest prior art could be very different from defining
Yes.
the problem as cleaning the corner of the room.
Yes. Yes, of course.
Okay.
Correct. Okay, to a similar use. Let us discuss the similar use. What is the use of this one?
In the room.
To clean the room. And this one?
Same.
The same. And this one? The same. Okay, we have one similar object to clean the room. But in addition, why is developed to accompany this one and not this one?
You don't need a person to operate it.
Don't need a person to operate it. Okay, let us look for... Do you need a person to operate it? Yes. Do you need a person to operate it?
No.
No. And for this reason, we may say this use is more similar compared with this. The object of the technical solutions are more identical or more similar compared with this one. This is the first reason why we can say, okay, we consider this one as the closest prior art. Okay. And requires the minimum of structural and functional modifications to arrive at the invention. Then you have to look for the first claim, for example. The first claim refers to the protection, and you look for the features of this one. The features may be, there is a vacuum cleaner robot, the first feature. The vacuum cleaner robot comprises means in order to clean the room. Suction means, for example, suction means here, and suction means there, of course. And the third feature may be that the shape at the front is a rectangular shape. Yes, these three features. Let's start with these three features. Then we may say, okay, this is a cleaning robot. This is a cleaning robot. This is no cleaning robot. For this reason, with regard to the structural features, to the first structural feature, this is closer to this one compared. If you compare these two cleaning machines. And the second feature was, or further feature was, a rectangular shape at the front. This one has a rectangular shape. This one do not have a rectangular shape. For this reason, you may say, okay, the number of structural differences is equal, and for this reason, what is the closest prior art? What was requires the minimum of structural and functional modifications. This value is equal in both cases, but the object of the invention to a similar use. With regard to structural features, there is no difference. You have to look to make the same numbers of modifications in order to arrive at this one, but the purpose of this one was closer to this one compared with this one. For this reason, the situation is very clear. This is the closest prior art. Okay. Now we have to, please go to the next page. This is the closest prior art, and now you have to look for the different features. I said, or you said, the first different feature in our main claim is the shape. This has a rectangular shape at the front and this not. Okay? looking for the different features between the invention and the closest closest state of the art. And the next step is identifying the technical effects resulting from the distinguishing features. And you had an idea what is the different effect of this one. It is easier to arrive at a corner. Yes. Let me direct your attention to the arrangement of this brush. This is close to the front, and you do not want only to arrive at the corner, you want to clean a corner. And for this reason there is a need that the suction means are near the corners of this one. And here the suction means are at the opposite side, at the rear side. And for this reason it is very clear there is a technical effect due to this shape. It is easier, or it is not easier, but you can arrive at the corner and to clean the corner due to this one brush. Here is another solution. There are side brushes rotating, and in this one, in this way, this one shall clean corners. But you need, of course, 3 brushes, and here only 1 brush is necessary. This is a further technical difference, but let us go back to the shape. For this reason, you can say the technical effects is to clean a corner, or to clean a border, or clean regions near the wall, and something like that. This is a region, this is a technical effect. And then you have to formulate the corresponding technical problem. This means starting, if a person skilled in the art would start from this closest prior art, he has to solve the problem to clean the corner and regions near the wall. And now we can go to the second step. Would the skilled person, this is the last question, would the skilled person arrive at the invention by adapting or modifying the closest prior art because the prior art incited him to do so in the hope of solving the objective technical problem or in expectation of some improvement or advantage? Okay, now the examiner will look for the further state of the art. Okay, here is one. And he will look whether the missing feature, the different feature, is known from the further state of the art. And what do you say is the further feature, the rectangular shape known from the further state of the art?
Looks like.
Yes. We can say yes. A rectangular shape is known from the state of the art. Now, it's a question whether a person skilled in the art would combine or would amends the closest prior art in order to solve the technical problem. And if there is a description of this vacuum cleaner that the rectangular shape was designed in this way in order to arrive at the wall, in order to clean corners and so on, then there would be no inventive step. Yes, there is a clear hint for a person skilled in the art. The person skilled in the art has to solve the problem to clean the corners, and if there would be a description that a rectangular shape is helpful in order to solve this objective technical problem, then a person skilled in the art would amend the closest prior art by such a shape and would arrive at the subject matter of claim 1 in our case.
And description means that it's documented somewhere.
Yes, there must be a teaching. It is not sufficient that there is only the identical feature known from the state of the art. A person skilled in the art must realize that this different feature is able to solve his problem. And if there is a written description, there can be no doubt about it. There is a clear hint.
But does this written description need to be in a patent? Or could it be
It's a state-
anywhere,
no,
a newspaper article?
Yes, known from the state of the art,
Okay.
anywhere. By a presentation, or a hearing or something like that, or a written description, but as a rule, the European Patent Office will only look for a written description because an examiner was not present during a hearing or something like that and cannot say something about that. If you disclosed an invention due to a conversation or something like that, then a third party, the other party may say, oh, the inventor told me his invention prior to the filing application date, and for this reason I will file an opposition, for example, or I will take other nullity actions, and now I can destroy a granted patent due to this disclosure. But of course the European Patent Office or Patent Office is not able to present such a state of the art. It is always a public person who will present such prior art during nullity action. Okay.
So if I combine two different things in a wise way, so they get a new or an improved combination out of it, that's not novelty. It's not considered as novelty.
If you have to combine something
I had to combine whatever this feature with
with this feature,
this feature.
this has no influence cannot destroy the novelty, because this is a combination.
But what if it's obvious?
This is
Because for this it was described that it needs to be a shape, needs to have the shape to reach the corners. For this it was whatever described that it needs to be like that to work without person, and then someone combines it, work
Yes.
without person, and that's an invention. That's a
that can
patent.
destroy the inventive step. The combination. The combination will destroy the inventive step. If you looked for a prior closest state of the art, you looked for an objective technical problem due to a missing feature, which was not known from the closest prior art. The missing feature was the rectangular shape. And you considered the patent application, and the patent application, the description discloses, this is of importance, of course, as this is written in the description of a patent application. The patent application discloses that the rectangular shape will contribute to the solution how to clean a corner. And now, with regard to inventive step, it is allowed to make a combination, and you have to look whether a person skilled in the art would combine two pieces known from the state of the art in order to solve the technical object. This is of importance in order to solve the technical the objective technical object. Yes, and if there is no written description in the state of the art that this rectangular shape is helpful in order to clean the corner, there is a first possibility that you may say to the examiner, okay, the same feature is known from the state of the art, but there is no hint for a person skilled in the art that he can solve the objective technical problem. And for this reason, a person skilled in the art would not combine this closest state of the art with this shape in order to arrive at the, and would arrive at the invention in an obvious manner in this way. Yes?
So would it be would it also be possible to patent a new application for an old prior art if I disclose or if I discover or if I have the idea that there is a tool already existing and it's not written down that it's used for or it can be used for this and this purpose, is it possible to patent a different purpose for
This may be,
an
yes.
existing? Okay.
This may be, but you have to, now we will look for further possibilities, and for this reason you may understand the point. You have to look for a different feature. This may be a different instructional feature, or that you use a known device in a new way. Yes, this may be a different feature. Is this possible?
Okay.
To get patent protection for a device as such, or for a new method, a new method step, there must be something what is not known from the state of the art in an identical manner. Then you will the state of the art cannot destroy the novelty of your invention, and then we have to discuss about the inventive step. Let us assume there is a written description that this shape is helpful in order to clean the corner. Then the missing feature is, starting from this one, the missing feature is the rectangular shape, and there is a description, please use the rectangular shape in order to clean the corner. Okay. Now, the situation is not over for the inventor. We have further possibilities. We may say, okay, we may add, for example, to the corresponding claim, which defines the scope of protection. We may say, okay, one further difference between the two machines is the arrangement of the brush, of the main brush. This main brush is at the front, but this main brush is at the rear. And for this reason we may add to claim 1 a further feature, a further structural feature, and say, okay, I want to obtain patent protection for a vacuum cleaner robot having a rectangular shape at the front and a brush which is arranged at the front, adjacent to the front, for example. Yes? And now we have to look for this one. Do this one disclose a brush at the front? Oh, catastrophe, it's the same. For this reason, we may say, okay, and if we would add this further feature to our claim 1, this will be not lead to will not have the consequence that an examiner will grant the patent. Okay. Now we have to look. This is the work of a patent lawyer. Of course, we have to look for a further difference. Oh, we see a further difference is the arrangement of the wheels compared with the arrangement of the brush. Here, the wheels are behind the brush. All wheels are behind the brush in this direction, yes. And so here the wheels are at the front. Okay, now we can say, okay, dear examiner, we would like to have patent protection for a vacuum robot cleaner having a rectangular shape, having a brush at the front and the wheels behind the brush. And in this way, for example, we may argue this arrangement will solve the problem that no hairs can block the wheels because the brush will collect all hairs, all dust, and this will help us in order to avoid that hairs will block the wheels after some time. Yes, for example. Now, the examiners will say thank you. We will have a look to this machine. And what do we have to say? Where are the wheels?
Behind the brush.
Behind the brush. And for this reason we can say, okay, this further structural feature in our plane 1 cannot have another result. And for this reason we have to think about a further difference. And now we say, okay, these two wheels are motor driven. And now we say, okay, dear examiner, we would like to have patent protection for a rubber cleaner having a rectangular shape and a brush at the front, and wheels behind the brush, whereas the wheels are motor driven. Okay.
And he plays music.
Let us have.
It's an exhaustive job.
Yes, this is a different feature. Yes, this is a different feature. These wheels are motor driven compared to the brush. These wheels are in front of the brush, and let us have a look to this one. No motor driven wheels, and for this reason we may get patent starting from the closest prior art. There is no hint in the further prior art to provide motor-driven wheels behind the brush. And then there is a feature which is not known from the further state of the art, and the result may be that the inventor will say, okay, I'm convinced, I didn't find a teaching to provide motor-driven wheels behind the brush, and for this reason there is an inventive step. We can present further arguments, and what I have learned, this is a conventional design, the circle design is the conventional design in the field of vacuum cleaning robots. For which reason? The reason is that here the person will move like this, but a vacuum cleaner likes to turn around like this, and if there is such a design, this is not helpful in order to turn around, to make a turning movement when the vacuum cleaner is in a corner, will arrive at a corner, and for this reason this is a conventional design of vacuum cleaner robots. And for this reason we may say to the examiner, there was a hindrance for a person skilled in the art to provide a rectangular shape with regard to cleaning robots, because in this case a cleaning robot has to overcome the problem how to leave a corner. And for this reason we have, of course, if everything has been disclosed in a patent application, a further description may refer to this problem and say, okay, a vacuum cleaner has a problem to leave a corner if there is a rectangular design, and for this reason we took further measures in order to solve this problem. And if you disclose such a solution for such a problem, then there will be no problem to get patent protection for this one. You have to amend further features how to solve this additional problem, and then such a vacuum cleaner cannot teach something, because such a problem is not relevant for a vacuum cleaner which has to be handled by a person. Okay, and now a demonstration, of course. of the vacuum cleaners. It's the end of my lecture. I don't know if you realize this.
Und sogar die Stuhlbeine.
Ja.
Das ist ja toll.
Okay. And I hope I could demonstrate the following. If something is new and you disclosed in a patent application a lot of details, there are a lot of possibilities in order to overcome the requirement or to fulfill the requirement that there is an inventive step. It may be that there are similar sorts known from the state of the art, but with regard to your special products, as a rule, there are additional problems and you have to overcome additional problems in order to adapt a principle, a known principle, to your special product. And for this reason, you may say, okay, the principles are known from the state of the art. And I took some principles known from the state of the art. I took the rectangular shape, but further adaptations were necessary so that I could adapt my cleaning robot in our case by modify a cleaning robot by a rectangular shape. And for this reason, it is necessary that you also disclose the further steps in order to transfer this solution to your special product. And for this reason it is of importance that we know a lot of details about your products and about all the problems. And in this way, if your product is new, we have a good chance to get patent protection if we disclose a lot of details, but I wanted to demonstrate that at the beginning it seems clear, the combination will lead to your product, but if you look for further details and for further amendments and for further differences, you will come at the end to a protection which is new and inventive, or to a claim which is new and inventive over the state of the art in this way. Okay, do you have any questions?
Yes. What if, I mean, for example, when you're showing the wheel differences from the new invention compared to the old one, what if the patent application for the old one would have stated that the wheels are behind the brush or in front? Instead of and,
this
they
one
would say, yeah,
this
they
one
would say
okay,
or.
then this may just this is no different feature, yes.
Mhm.
We have to look for different features when this is the closest state of the art.
Yep.
And we will add further features to claim 1. We have to look for features which are not known from the closest state of the art.
Mhm.
If the arrangement of the wheels is already known from written description of this vacuum cleaner robot, this would be not helpful.
Okay.
Because this is no missing feature. This is a feature already known from the state of the art, and for this reason we cannot say there is a further feature not known from the state of the art, and there is no hint for a person skilled in the art to look for the further feature in order to solve a problem.
So is it fair to say that the more narrow and more precise we define, especially the first claim, the easier and the more likely it is to get a patent granted, but on the other side, the easier it also is to get around it, because
Yes,
it's
of
so
course.
narrowly
Yes.
defined. So that's
Yes.
kind of a trade-off.
Yes, of course. This will be the result. The more features are in claim 1 or a further independent claim, the smaller is the scope of protection, and it is easier to come around to a claim comprising a lot of features.
And second question is the kind of the verdict of the person at the patent office. It's basically just a verdict until somebody challenges it, or is that once it's stated by the patent office, is it then a fact, like a referee in a soccer game?
If a patent office granted a patent, then a third party would violate your right if the third party falls in or a device of a third party comprises all features of claim 1, for example. But a third party is able to attack the patent and say, okay, here is further state of the art. The further state of the art has, for example, has not considered by a European Patent Office, for example, or other patent office, or the European Patent Office considered the state of the art but in the wrong way. And for this reason, please, the third party may file a nullity action and destroy the patent. This is possible. But at the beginning, if there is a patent, this would be an infringement, and you have to think about the situation, the following situation. If there is a patent, and you will go to a patent lawyer and ask the patent lawyer, do I infringe this patent? Then the patent lawyer will say yes, okay, there is a clear infringement. And then the third party will ask, here is state of the art, is the patent valid over the state of the art? And then the patent lawyer may say, no, it's invalid. And then the third party will ask, dear Mr. Patent lawyer, can you guarantee me for this result? And then the patent lawyer will say, no, I cannot guarantee for this result. And then the third party will ask, when will I am sure that the patent is invalid? Or will the patent lawyer may say, okay, we will file a nullity action, and 3 or 4 years later you will have the result. And this means that a third party have to wait for a lot of years, and afterwards the third party is able to say, okay, the patent, or we will know whether the patent was invalid, and that there was no, as a result, a third party never infringed a patent, or whether a court will say, okay, the patent is valid. And if you have to wait for 4 years and where you will produce for 4 years, then you have to pay damages for 4 years, for example. If the patentee filed an infringement action, and if the meaning of the patent lawyer was wrong, that a corresponding court will revoke the patent. And for this reason, there is a high risk for a third party to infringe a patent only due to the meaning of the patent lawyer that the patent is invalid. And for this reason, a patent is a very strong measure in order to have some advantages. Despite the fact whether the patent is invalid or not, the reason is in order to learn or to destroy the patent, you have to wait for a lot of years, and this is your advantage. This is the advantage of the patenting. And there are a lot of situations in our office that there are companies coming to us, and the companies ask us, okay, what do you think about the validity of the patent? And I say, okay, I think you will be successful, but I'm not sure, of course, because I don't know how a judge will decide. And you have to wait for 4 years in order to be sure, and please keep in mind the damages. And the damages are much higher at the moment in Germany compared to the past, due to further development of case law. And for this reason, please develop a product which does not infringe the patent, so you can sure that you do not have to pay damages within at the end.
And what about whatever the situation that I filed or that I would like to apply for a patent, and claim 3 of the patent is invalid? Would they say, okay, you can patent it, but you have to remove claim 3, or is it all the way in your application?
There is an exceptional case that, my understanding is claim 3 depends on claim 1. As a rule, a dependent claim cannot be invalid if claim 1 is valid. But there is one exceptional case where this may happen, and in this case you may delete claim 3.
Okay.
But this is a very complicated case, and it is not helpful for you to explain this exceptional case.
I
Do you
just
have a
wanted
question?
to.
Mr. Schmitz, do you have further questions?
Not immediately.
Okay, and let me emphasize once more, if there is something new, if there is a new development in your country, and this new development, you believe this will have value for your company, then you should go to the patent lawyer, because there are so many possibilities in order to overcome the requirement with regard to the invented step. What is of importance is that you discloses or explains a lot of details in order to have the chance to obtain patent protection, despite the fact that the principles are already known from the state of the art.
Exactly the question what Christoph asked earlier. So basically, for patent you need to have a technical problem and then a technical solution for it. What if you have a technical solution for another problem? Can you still, make a patent out of that?
This is a difficult question. You may have the chance to obtain patent protection, but it may also be the examiner may say, okay, you solved a further problem, but starting from the closest state of the art, there remains the old one, the old problem, and in order to solve the old problem, a person skilled in the art would amend the closest state of the art by the missing feature already known from the state of the art, despite the fact that the purpose is different. This may be the result, but often there are other possibilities. For example, that you will amend claim 1 by use feature or something like that, so that you can say, okay, the new use in order to solve the new problem. This is not known from the state of the art. Then there is a further missing feature not known from the state of the art, and there is no hint to take the closest state of the art, to use it in a new way in order to solve a new problem, not known from the state of the art. For this reason, you have to consider the situation. Both results are possible.
But I think about a patent document, it generally has, I don't know, between 10 and 20 pages, but the claims is just basically half a page. What's the purpose of all the rest? Is it to describe how to arrive at the closest prior art?
No. At the beginning, two purposes. The main purpose is to inform the public about your invention.
Description.
It's
By
all
a
the
description and the figures. The figures are not necessary, but the figures are helpful in order to understand the invention. And the claims defines the scope of the claim. Claim 1 defines the scope of protection, and there may be a further independent claim saying not, for example, claim 2. According to claim 1, this would be a dependent claim if there is the wording. Claim 3, for example, suction or vacuum cleaner robot comprising the following features. This would be an independent claim and would define a further scope of protection. But in order to look whether there is an inventive step or not, you have to look for technical effects, and for this reason the description is also necessary in order to show that there was an inventive step necessary in order to arrive at the invention. But at the beginning, the description is necessary in order to inform the public about your invention. And the description is also necessary in order to have possibilities to amend your claims in such a way that you will get patent protection.
Last question, this kind of reproducibility that has to be in this description of the patent, because you said somebody, what do you say, knowledgeable or familiar with that type of thing.
Skilled person.
Skilled person, thanks. Must be able to repeat the device that comes out of that.
Yes, of course.
But that's not based on actual doing, it's based on the judgment of the person at the patent office.
Yes, but as a rule, in our technical field, we do not have problems with this requirement.
Okay. Because otherwise one could challenge a patent. I would try it, it doesn't work.
Yes, of course. A lot of persons always tries if they file an opposition case or a nullity action. The beginning is the person skilled of the art is not able to carry out the invention. The invention has not been disclosed in a sufficiently manner. This is
but because it's difficult, it turns around the burden of proof.
I never had the case that a patent has been revoked in the technical field due to this objection.
Okay.
This is an objection which may be successful in the chemical field, because in the chemical field it is much more complicated to produce something or something like that, or there is a formula and
you don't
nobody
disclose certain parameters.
Yes, parameters, for example, and nobody is able to produce it. This would be a typical situation that a patent office may come to the result, okay, you disclosed a new material, but you didn't explain how to produce it, and for this reason the person skilled in the art is not able to carry out the invention. But in the technical field, I never made the experience that an opponent was successful with this objection. One time, the first instance revoked the utility model, and the patent court said at the end, this was nonsense.
Well, because you know, we have the device side where we're talking more about technical things, but Timo is our head of R&D in Estonia, where we deal with the powder and the stuff, so that's more close to the chemicals side. That's why it's not entirely irrelevant for us. So is it possible that such a court case then ends up in the laboratory?
Yes.
And then people...
No.
No?
A judge will never come into a laboratory. He will decide due to reports and statements and facts and evidence of the parties.
Okay.
And if there is a corresponding objection, and we have to furnish proofs that a person skilled of the art is able to carry out, to produce a new material. We have to provide facts showing and evidence showing that the person skilled in the art would be able, due to the description, to produce the material, and of course an opponent would say, would provide further evidence showing that a person skilled in the art is not able to produce it, and at the end the judge will take a decision about that point.
It's a Gutachter also, I don't know the word, just like
Yes,
independent.
it may be that
evaluators.
there is a technical expert, but as a rule there are a lot of technical experts. A board is composed of technical experts, chemists, physicians, or persons which are familiar with the chemical field, and for this reason they say no, we do not need a technical expert because we are technical experts.
And what is it about whatever I have to write it down in the lab book at the time I had the idea? What is actually what's the protection of that if I do it? Whatever because the filing date is there.
You
Am
have
I
to
allowed
file a
to-
patent application. In the USA, the date of when you made an invention is relevant, but you have to furnish proof that you made the invention prior when you made the invention, and in this way you may get an earlier date in the USA. But in the moment, the US government tries to amend this and to amend the Patent Act, and that in the future the filing date will be irrelevant, because it is very difficult to furnish proof when did an inventor make an invention, and for this reason all the other countries for all the other countries the filing date is relevant for the question what is state of the art and what is not state of the art.
And it's also not that way that whatever there is an invention, there is a filing date, and I prove that I had a similar idea and may use it then. It's also not
If
that
you,
I don't-
if you
that I
didn't,
don't-
if you have no earlier rights, you're not allowed to use
Okay.
your invention.
So it's really the filing date of the patent.
The
So
filing
the
date
lab
of the
book
patent.
and whatever quality is of less importance.
Yes. It may be that you already disclosed your invention prior to the filing date. Yes, then your disclosure will destroy the novelty
Yeah.
of the patent. But if you didn't disclose your invention, there is no way to use it. There are some exceptional cases, but as a rule, you're not allowed to use it.
So if I would file it, of course I would destroy my rights. If I disclose it, I would destroy my rights to file a patent as well as
Yes.
anyone else's rights.
Yes.
And so it would be, I would carry it to the public to get it used, and nobody would be allowed to
If
file
you
a patent.
disclose it by a paper,
Yeah.
Dieter likes to disclose inventions by a paper,
Yeah.
then he's not able to,
To file a patent.
yes,
Of course, no one else is.
of course no one else, because this disclosure destroys the novelty of identical
Okay.
inventions disclosed by a patent application.
I just was referring to that because there is always the claim of the lab book and why the lab book has to be kept that clear and filed of pages and so on. This is more related to the US
Once more.
right, patent right, or is
Once
it
more, I didn't
in
read it.
principle?
Answer your question.
It's always said that the lab book is very important to be. There are several rules for a lab book. There are no empty pages. The date has to be there. No torn pages or whatever. That's only to U.S. patent right.
To disclose a lot of details.
No, for application of the patents, what you were, Christoph, is getting at into our laboratory practices and define it.
Okay,
By
yes,
the,
now
by
I
the,
understand.
by the
Yes,
European
yes.
law, it's
Okay.
defining dates.
Yes.
So US,
Mhm.
the US law still can and,
Yes.
and is capable of, disclosing it based on the prior invention where this lab book practice, what you're saying,
Yes.
states. But in European patent law, it's defining
It's
dates.
defined,
Yes.
Yeah.
Sorry, I didn't understand
No.
at once. This is only relevant for
Mm.
the US in order to furnish proof. When did you make the invention? In order to obtain a date prior to the filing date.
What about the inventors listed on an invention? What are the rules? How do you define a contribution of a person and then figure out whether you're required to list that person as an inventor or not? You know, our Estonian friends always have a ton of people who apparently contributed to their inventions.
Yes. These persons are inventors who contribute to the new idea. If there are further persons developing something but which does not contribute to the idea, which is at the end new and inventive over the state of the art, these persons are no inventors.
But it's a
For
gray, it's a
example-
gray thing, isn't it?
Yes,
It's
for-
not black and white.
Yes, for example, a person will say, okay, I have the following problem, but I don't have a solution for this problem. Then he contributed to the development of a new device, but he's no inventor because he didn't contribute to the solution. Yes, but I think, forget it, in practice, yes, in practice, you have to look for your stuff, and if somebody says, I'm a co-inventor and I will leave your company if I'm not the co-inventor, then you have to take the decision if you're interested in this person that he is a co-inventor. And for this reason, there are a lot of patent applications and there are so many inventors and there is only one idea. And
So it's even the theoretical question whether so many people can contribute to one idea at all. And who's to challenge that?
This is not relevant because it is only of importance. The inventor has the right to file a patent application or the legal successor. For this reason, if the applicant, and as a rule the applicant is a company and a company is not a person, and for this reason a company cannot be an inventor, you have to make sure that the company is allowed to file the patent application.
So the employees must have assigned their rights to the
As a
company.
rule, an employee, an invention of an employee, an employer is allowed to file the new ideas or to file patent applications due to inventions of the employees of this company. This is a rule.
Okay.
There are also exceptional cases, but as a rule, if there is an inventor in your company, then the company is allowed to file the patent application due to this relationship. But if there is a third person who is not an employee in your company, and the third person will say, okay, dear Mr. Badegruber, you are allowed to file my idea as a patent application, you have to make sure that there is a document showing that your company was allowed to do this. Otherwise, you may run into problems. Okay, further questions? No further questions?
Not at the moment.
Thank you.
Thank you.
Okay.